So I have a question that follows from that. Uh, each of these jurisdictions in question have approached it in their own way. So, what distinguishes one jurisdiction from another? So, for example, if someone is an entrepreneur or a trader, or they want to set up an exchange or whatever it may be, why should they choose one jurisdiction over the other? So, for example, in Dubai, in the Emirates, sorry, all in, you probably have like 45 free zones, but you know that certain free zones are good for this. If I wanted to set up this type of project, this is the free zone I need to go to. If I want this type of structure, I need to go to the other, and so on and so forth. Is there any such distinction within these Caribbean jurisdictions?
I would think not really, and I explain why. So, for example, the distinction would come from not necessarily legislative response, because the laws are broadly identical anyway. Cayman, BVI, the model Eastern Caribbean Central Bank bill, they all have a common definition of what a digital what a virtual asset is, being a digital representation of value that can be digitally traded or transfers and can be used for payment or investment purposes, but does not include digital representation of fiat currencies or a digital record of a credit against a financial institute of fiat currency. So that excludes CBDCs. So, for example, in the Eastern Caribbean, you have Dcash, which is digital cash, which is a digital representation of the Eastern Caribbean dollar. Or in the Bahamas, you have the sand dollar, and so on and so forth. So broadly, they have the same definition. They cover the same things. So virtual asset service provider, VASP, that's a common acronym between the Cayman and the BVI. And it's a VAA, I think, virtual assets, VAP, I think, in the Eastern Caribbean. So they're broadly similar. So the differences come in terms of what exactly is the aim of the person who is setting up a virtual asset service provider. So, for example, Cayman and BVI, initially brand name value. So Cayman and BVI have the largest amount of ancillary support services in the Caribbean offshore world. Cayman, you have the big 6 or so big firms that also span Bermuda, London, Singapore, Hong Kong, and the BVI themselves. So you have the big law firms and the brand name value of Cayman and BVI. But if you're looking to be more off the books, or let me not say off the books, see that I already said fraud, but off the beaten path, you have the more, I would say, the more gem-like or the more pearl-like jurisdictions, St. Vincent, St. Kitts and Nevis, that are smaller. You tend to find more traders. You tend to find much more traders in these jurisdictions as opposed to crypto exchange platforms, which are bigger and would require naturally something of a more brand name. So I think that's a central difference. As to the effect of the regulation, what I've noticed is that Nevis in particular, Nevis has a very high fee. I think it's something like 55,000 Eastern Caribbean dollars for the application fee and like 100 and something thousand for the license. St. Vincent has not yet commenced its application of the Virtual Assets Act, so we don't really know what the application fees are like. Antigua, it's roughly the same. So it's roughly about maybe, what's that conversion like? About 25,000? What, 25,000 US? So less than, what's Bitcoin at now? That's like 1.5 Bitcoins for the application fee, and maybe roughly about 9 Bitcoins for an annual license. So, it's not that unmanageable for a successful trader, depending on the market being notwithstanding its volatility. But there are opportunities for the discerning trader. And of course, consumer protection. What a big aspect of the regulation is about consumer protection. And you could only get your license under the Act if you provide a prospectus, details of dispute resolution mechanisms, and of course, there's also a statutory bond. So in the Eastern Caribbean, there's also a statutory bond. So in the event that the trade or the corporate entity goes bust, there's at least some money available to go out in a liquidation. So the state isn't left high and dry, so to speak. So, for example, in St. Vincent, that statutory bond is 100,000 Eastern Caribbean dollars, which is about 50,000 US. So that's just held in escrow by the state, and you get that back when you wind up your business. So there are a range of things that the legislation provides for, which I think are a useful response to the more shady side of the crypto asset world. So maybe let's just signpost and say the treatment of crypto assets in the Eastern Caribbean and the broader Caribbean is that, well, it's recognized, it's regulated, and it's used. And it's a matter of an individual taking legal advice, which would be tailored to their particular instances to understand the pros and cons for them.
So if you're a 6, 7, or 8-figure investor, entrepreneur, or business owner who needs a tailor-made solution from a qualified team of professionals, we can help you achieve the international lifestyle, the freedom, and even the tax savings you're looking for. Visit us at htj.tax and live that international life.